Supreme Court of August out session, the Honorable Chief Justice Robert J. Torres presiding.
Good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA24-019, People of Guam Plaintiff Appellee v. Gregorio Trio Denamarquez Jr., Defendant Appellant. Appearing for Defendant Appellant is Attorney Peter C. Perez. Appearing for Plaintiff Appellee is Attorney Christine S. Tenorio. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Perez reserves 10 minutes.
Mr. Parrish, you may proceed.
Good morning, Chief Justice Torres. May it please the court. In this case, Mr. Denamarquez was indicted on 5 counts of CSC that were all contact theory. The contacts alleged in first, second, fourth, and fifth counts were the buttocks, and with respect to the third, it was the inner thigh. The trial evidence included that the defendant denied the allegations. Witness testimony was that his conduct was normal, that it was unintentional, that it was incidental, accidental, playful, that it wrestling. It's the same type of conduct he committed with his own children and with the victim's siblings. The conduct alleged occurred in the presence of other persons. There was evidence that it was not sexual. It was described also as okay. So there were multiple inferences that could have been derived from the evidence, including that the conduct was innocent and non-sexual. In the briefs, the people concede. In fact, they agree and emphasize that the touching had to be for sexual arousal and gratification, and that they had the burden of proving beyond a reasonable doubt that not only that Denamarquez did it, but that he did it for sexual gratification. However, the instructions that were given to the jury in this case did not require that. They did not require that the people prove that the jury find beyond a reasonable doubt that Denamarquez's contacts were actually for sexual arousal or gratification.
The statutory definition of sexual contact, which is at the jury instruction 6E, had the specific language that if that intentional touching can reasonably be construed for the purpose of sexual arousal or gratification. Why isn't that sufficient? Why doesn't that cure any ambiguity that may exist with regards to element 5 in the instruction 7A to 7E?
A couple of reasons. One, the definition of sexual contact was actually made an element, and two,
Was pardon, I missed that.
was made an element. It was made an element of the offense at the request of the people. So instruction 7A through 7E made that an element. Secondly, as the court invited us to review the Cox decision, in Cox, the instruction tracked the statute. And the statute had a presumption that if you had a 0.08 blood alcohol level, that there was a presumption that you were under the influence. And that instruction was given to the jury. This court found that even though it tracked the statute like the Denamarquez instruction did, it nevertheless was erroneous to give that instruction.
Is there any significance that the defense counsel on the record accepted the jury instruction, both 7 and 6E?
I would say no, because the result was structural error. It resulted in I don't think you can consent to a constitutionally deficient reasonable doubt instruction.
Well, there's still a question whether it's plain error or structural error, and I'm sure we'll get to that. But if the trial lawyer in this case accepted the instruction and that it was, he or she had no objection, then does that constitute a waiver? And can this issue even be raised on appeal?
I think it can because, as we've argued in another case, and as we argued in our brief, the court does not presume waivers from a silent record.
Well, that's why I pointed out it's not a silent record. He accepted it on the record.
It's silent with respect to the defendant's knowing, intelligent, and voluntary waiver. There was no representation that the issue had been presented to the defendant, that the defendant understood the right that would be waived. So in that sense, I would submit that it was silent. It's not silent insofar as counsel, as a matter of trying to preserve the defendant's constitutional right to beyond a reasonable doubt standard, asked the court to remove the alternate inference language from the reasonable doubt instruction.
So if we accept your argument that there was no knowing and intentional waiver on the part of the defendant and the lawyer's acceptance does not constitute satisfy the elements of a waiver. So in addition to giving the instruction 6E, both the prosecution and defense in their closing arguments addressed and made it clear that the government had the burden of proof beyond a reasonable doubt. Would the arguments clarifying the burden of the government in addition to instruction CE cure any potential misunderstanding of whether or not element 5 created an ambiguity?
No, because that was argument by counsel, and the jury was instructed that the arguments of counsel are not evidence. Furthermore, it was the court's duty.
I'm not in any way implying or stating that anything counsel says is evidence, but I think that doesn't address whether or not it constitutes a sufficient explanation as to whether or not who has the burden of proof beyond a reasonable doubt in this particular case.
The duty to instruct is from the court, not from counsel. And the court's instruction, notwithstanding the arguments of counsel, was inconsistent with what the law requires, which is that every element, in this case, one of the elements being sexual arousal and gratification, must be proved beyond a reasonable doubt. In this case, that was not the instruction given. The instruction given was if it can reasonably construed to have been for sexual arousal and gratification, which is a lower standard than beyond a reasonable doubt, resulting in a constitutionally deficient reasonable doubt instruction, resulting in structural error. And I don't think that getting to the standard of review, I don't think it's plain error. The Supreme Court has said when it is a constitutionally deficient reasonable doubt instruction, it cannot be harmless. It is structural. And
so your understanding of the structural error consequence is that it's automatic reversal, and there is no analysis as to how it applies when there has been no objection at the trial level to the instruction.
Correct. Now, alternatively, correct, but alternatively, if the court found, like another court found in one of the cases cited, that the harmless error standard applied, and the court in that case applied harmless error because not only were there sexual contact charges, but there was also a sexual penetration charge, and the evidence in that other case showed that the defendant had committed penetration and orgasmed. So even though there was a deficient instruction, it was harmless because the evidence clearly demonstrated.
But under no circumstances, as I understand this case, is this a harmless error analysis? It's either a structural error or how does it interplay with plain error? Because there was no objection to the jury instruction. Harmless error is if you did preserve an objection and it has a lower standard of review. Is my understanding.
Well, there was no objection. That's true. I don't argue with the court, but I don't concede either that harmless error required an objection. But if it did, let's say it didn't. If it didn't, and harmless error applies, which I don't think it does, because the evidence was ample that there was an alternative inference that could have been concluded from the evidence. We heard from the two parents of the victim who disputed the allegations. We heard from the brother who was present during periods when the alleged conduct occurred. They all said, and we heard from the defendant, we had the defendant's statement denying the allegations. We heard that through the mother and the victim's mother and from GPD. So there was ample evidence for the jury to have inferred, if they were permitted, that while on the one hand, okay, there was a contact, and we construe that as being for sexual conduct, for sexual arousal or gratification. We can also construe it as innocuous, because he wrestled with his kids, he denied it, it looked normal, everybody said that this type of evidence. We've got these two inferences that we can make. But because that alternate inference language was removed, and because
But it doesn't seem that the jury was confused. It did a pretty good job. It rejected 2 of the 5 charges and acquitted him, and then it found the defendant guilty on the remaining 3 charges, counts 3 to 5. And so while I understand, or at least I follow your argument regarding the innocuous consequence of the conduct, the touching of the defendant. So you don't think that with instruction 6E and the arguments of both prosecution and defense regarding the burden of proof, that addressed, explained, may have cured any shortcoming and any implication, any impermissible presumption on the part of element 5?
I just don't think that counsel can cure an error by the court. The court can cure its own error.
Well, I mean, if your argument is the court committed error by adding element 5 to the sexual contact or second degree sexual conduct violation. That's correct? Is that what you're, and that in itself, absent anything, totally irrelevant what was said by defense counsels. You know, we've have a case law that you read the jury instructions as a whole. So none of that matters in reference, just because element 5 was issued, that in of itself results in a structural error.
It's not just that element 5 was instructed, it's that the instruction overall, reading all of the instructions together, was constitutionally deficient. Because if you say to the jury, you must convict if the people prove beyond a reasonable doubt that the touching can be or could be construed as for sexual arousal or gratification, you're basically saying they don't have to prove beyond a reasonable doubt that it was for sexual arousal gratification, resulting in a lower standard of proof.
See, that's where I'm having a disconnect with you as well. The argument can be made that adding element 5 may have raised an impermissible presumption that relieved the government of its burden. That argument seems to be in a vacuum, and it doesn't take into account that instruction 6E defining sexual contact, which tracked the statute. And in addition to the explanations of the prosecutor and the counsel, may have clarified any confusion on the part of the jury.
It's like the example given in the case, in that state case, where it said, You have a situation in a bar where a guy turns and he accidentally bumps into a woman and touches her breast. Well, the jury's presented with that. It could be inferred that that was for sexual arousal and gratification. And if the jury could infer that, they must convict, even though it could also be inferred that it was accidental. He didn't even see her, he just bumped into her. That's the concern with this type of instruction, because you remove the jury's discretion to consider a non-guilt inference. If it can be construed this way, even though it can be construed in other ways too, the jury must convict. That is what their directive was. And that's one of the main problems with these instructions. It's not just that it was made an element, it's that the jury was directed that it must do this. And under Cox's case, which we were invited to comment on, when you remove the jury's discretion, you take away their ability to credit or reject evidence, then you undermine their role as fact finders, and that's not permissible.
But the jury was still required, if you look at the elements, you look at instruction 7A, the jury was still required to find that, and the people had to prove beyond a reasonable doubt that the defendant engaged in sexual contact with another. And the definition of sexual contact is the intentional touching, if that intentional touching can reasonably be construed for the purpose of sexual arousal or gratification. So the instruction said they had to prove sexual contact. That was an element 4, and it had to be proved beyond a reasonable doubt. And 6E had the definition of sexual contact, that intentional touching can be reasonably be construed for being for the purpose of sexual arousal or gratification. So really, element 5 seems to be unnecessary.
I agree. Element 5 was probably not, they probably did not need to be instructed that was an element, but that does not cure the deficiency, because you still have to consider the definition, and you're qualifying, the instruction qualifies what the people must prove beyond a reasonable doubt. They need to prove that there was a contact, and they're supposed to be required to prove the contact was for sexual arousal and gratification, but they're not required to prove that. They're required only to prove it could be construed that way. It's possible that it was that.
But if they had to prove sexual contact as an element, which they had to do, I mean, it says they had to prove that beyond a reasonable doubt.
Right.
And if they had to prove sexual contact, and sexual contact is only sexual contact if it's for the purpose of gratification.
It's not. Can it be construed as for that? That's the problem.
Yeah, well, that's the definition in the statute under 6E under 9 GCA 2510, that if the intentional touching can reasonably be construed as being for the purpose of sexual arousal gratification. So you can't prove sexual contact if that intentional touching can reasonably not be construed.
Well, what happens if it can be reasonably construed as sexual contact or not reasonably construed as sexual contact? What if both?
No, it's not sexual contact. It's, can it be construed as being for the purpose of sexual arousal?
Right. Right. With that correction, what if it can be reasonably construed as for sexual arousal and gratification, but it could also reasonably be construed as accidental, playful, or non-sexual? Because
But by finding that it can reasonably be construed for the purpose of sexual arousal or gratification, they have determined it can't be construed as not being for sexual arousal.
I don't think the instruction reads that way. It does not. It's not mutually exclusive. The problem is you could have both inferences and the jury nevertheless is directed to convict. And therein lies the problem. Because again, we have the example of the man in the bar touching the woman's breast. If you touch a woman's breast who you don't know, Can that reasonably be construed as for sexual arousal and
Well, that's up to the jury to find if it could reasonably be construed for the purpose of sexual arousal or gratification. That's their decision. And if they determined it wasn't, he would be acquitted. If they determined it was, he would be convicted.
Not if they can construe it as being for sexual arousal gratification, but they could equally construe it as an
Well,
incidental.
it seems to me they have to make that decision. That decision is left for them by having them prove sexual contact. They have to, under the instruction, under 7A, that people had to prove beyond a reasonable doubt that the defendant engaged in sexual contact. And if he engaged in sexual contact, that meant he had intentional touching for the purpose of gratification. I guess you're looking at it in conjunction with this alternative inference instruction that was also provided under 1E. But if you know, the instruction wasn't included, but if the judge had included the instruction, wouldn't that suggest that there's a lower standard of proof as opposed to excluding the instruction?
I think, and that was the concern of trial counsel, and my response is maybe, maybe not, because it did create a mandate. If you had the alternate inference language in there, it created a mandate to the jury that if you could construe it equally reasonably to have been innocent or guilty, you must adopt innocence. Now, in this case, we had the flip of it. We had, if you can reasonably construe it as guilty, you must convict. You can't even consider a non-guilty conclusion, even though there was ample evidence to support a non-guilty conclusion. If there are no other questions.
Just one follow up with that. So there's because the alternate inference instruction was not given, does that in any way affect the reasonable doubt burden in reference to element 5? Is there an interplay there, or can one stand without the other?
The removal of that language compounded the problem, because it removed the instruction that directed the jury to consider if there are alternative inferences, adopt the one of innocence. You remove that, then you're directed, if it can be construed for sexual arousal and gratification, you must convict.
But what if the facts is that in this particular case, the alternate inference instruction was not given? But if the court was to view that the element 5 did not create an impermissible presumption of guilt, and that reasonable doubt instruction was sufficient, does that cure any shortcoming of not giving any alternative inference instruction?
If the
In other words, the alternate inference instruction, if that was not given, that in and of itself doesn't mean that there was error, reversible error in this case.
I think it depends on what the instruction was given regarding the underlying offense. The problem is there's this directive, if you can infer, it can be construed as for sexual arousal and gratification. You don't have any discretion to consider anything else. You have to convict now. So that's problematic on its own.
So this case stands one way or the other on the reasonable doubt argument rather than any alternative inference instruction.
From what I recall, that yes, but the alternative inference instruction, I think, was part of the reasonable doubt instruction. I think it was at the end. So you have a standard reasonable doubt instruction that is then diluted, lowered by the elements. And then you remove the alternate inference instruction language. You deprive the jury of exercising its discretion to credit or reject. inferences that they could have made regarding the evidence. So it's in it either way. Problem, it impermissibly affected the reasonable doubt instructions
So
together.
your argument is that the alternate inference instruction, not giving that, compounded
Correct.
the problem of whether or not the reasonable doubt instruction was sufficiently given.
Correct. It comes down to interfering with the, well, you're directing the jury to find a certain way if you can infer a certain way, even though you can refer another way. And when you remove the inference, alternate inference instruction, then the jury doesn't know that it must adopt the non-guilty inference. But I mean, the bigger problem is the instruction itself, with or without the alternate inference instruction.
All right, thank you, Mr. Parrish. You have 5 minutes remaining. Mr. Tenorio.
Mr. Chief Justice, may it please the court. The jury in this case understood that they had to distinguish lawful contact versus unlawful sexual contact. They did that by convicting the defendant of 3 counts and acquitting him of 2 counts. The history of the added element was because in the past, appellate counsels have argued that if you don't define the sexual contact specifically as an element of the crime, then somehow the people did not meet the burden of proof. That is the history of the added element. The added element simply defined what sexual contact is under the Guam definition.
But there were 2 incidents in my mind, a scenario that creates some question in reference to the outcome of this case. Number 1, it had to do, I think I just lost my train of thought. What was number 1?
Deleting the word if.
Well, that too, in terms of the element 5E and in terms of the jury instruction. And why don't you address that first, and then my train of thought may come back in reference to the 2 incidents. Okay, okay. The first incident had to do with, in reference to the jury sending a question to the judge to clarify what incidents align properly with the various counts that were charged, seemingly having some confusion. That's one incident. And then the second had to do with defense counsel's closing argument in reference to that defense had to show it had the burden to show beyond a reasonable doubt. I'm sorry. It had to show beyond a reasonable doubt that where a prosecutor was questioning a witness, that they had the burden to show that the witness was not testifying truthfully, and that they had that burden, that the defense did. So if I guess if the jury confronted with those 2 incidents, that that may have contributed to a misunderstanding in reference to who has the burden of proof, because here defense counsel says it had the burden of proof in terms of showing beyond a reasonable doubt, although something not related to element 5. And also when the jury did send a question to the judge that seemingly expressed or implied some confusion in reference to the charges, that there may have been some misunderstanding regarding possibly the burden of proof.
To your honor's first question about the jury question, I think that's an issue separate and apart from beyond a reasonable doubt standard. It was because there was overlapping times of the incidents or differentiation as far as I was in X grade, but I was this years old. So the indictment itself charged by birth date. She had to be a certain age per year. And so I think that's separate and apart from the beyond a reasonable doubt, which goes to your second point. Now, if the defendant said that they had the burden of proof, that even if the defendant stated that, they were never instructed that in the jury instructions. Throughout the jury instructions, I want to say there are about 4 or 5 jury instructions that repeatedly say the people have the burden of proof, and it never ever shifts to the defendant. So for the and both the prosecutor and the defense did make the argument that the conduct had to be for the purpose of sexual arousal or gratification. So the definition itself is not error. When and I understand Mr. Pierce's argument that counsel can't correct error, but it wasn't error. It's prosecution and defense are clarifying that you have to basically find that this is not innocent conduct, and they did that. They did that for 2 of her birthdays, but not the other 3. And so in this case, the case law says that this is a general intent crime. It does not lower the burden of proof. And in this case, it did not lower the burden of proof because the top of the instruction on the essential elements says the people must prove beyond a reasonable doubt all of these elements of the crime. Mr.
Ms.
Harris.
Tenorio, isn't there an ambiguity created between what 6E says and what E says in the more detailed instructions?
As far as the deletion of if,
Yes.
I don't believe that there is an ambiguity there because the definition of sexual contact is given. And even if the word if was deleted, it's telling the jury and it can reasonably be construed, not that it's presumed that that it can be reasonably construed. That is dictating the jury. You have to find the contact and you have to find that it can reasonably construed.
But you could read that instruction that it is changing the definition by taking out the if.
So I understand your honor's question, but neither the prosecutor or the defense attorney read it that way. Everyone was joining in the jury instruction to further clarify the definition, and the ambiguity is alleviated by both prosecution and defense counsel saying the people have to prove that it was for the purpose. So there was no reliance on the reasonable person. There was no argument that or jury instruction that stated this conduct is accidental, but if someone can reasonably construe that as for the purpose of sexual arousal or gratification, then you have to go with the reasonable person instruction.
But if you just look at 7A, for example, it sounds like a statement concluding that intentional touching can be reasonably construed as being for sexual arousal.
So
Rather than saying to the jury, you must find this, it could be read as a statement of conclusion.
So I understand your honor's question, but I don't think that ambiguity was an issue for the jury because they were clear that you had to distinguish between playful contact, or innocent contact versus sexual conduct. So they took that role and they delineated specifically what acts could not be construed as for the purpose of sexual contact. So that goes to the Cox supplemental briefing. Now, even if the jury read it that way, and again, these are legal terms, but let's say the jury as lay people read it that way. Under Cox, it's a permissive, under Cox, it would be a permissive inference, but it's not a requirement. Still under Cox and then under the Supreme Court Ulster County case, it's not saying, jury, you must find that it was that it can, or the court is saying that it can reasonably be construed. Under this, it's saying, under the elements, it's saying the people must find this sexual conduct, you must also find that it can reasonably be construed. In rejecting two of the sexual contacts, that is the jury saying, we did not reasonably be construed those two acts of touching the buttocks as sexual contact. I think that
But wasn't the problem compounded, as Mr. Paris pointed out, by the removal of the two inference, the alternate inference instruction? And that so, you know, the jury then was not able to consider that if there are two possible explanations, that you favor the innocent outcome.
I don't think that it was compounded by this. First, I do want to say that it was the defense counsel that deleted that instruction. That is an instruction that prosecution gives and we leave in. But because he had a valid argument that he thought it lowered the standard of proof, I don't think it conflates the reason beyond a reasonable doubt standard. In this case, it's actually the opposite. At the trial court level, the prosecution, defense, and the court were under the impression if you remove the alternate inference language, then it makes more clear that the burden is beyond a reasonable doubt. And that was specifically requested by the defense counsel. And so the prosecutor did not object to the request. So I don't think it's conflated because, again, the jury was given instructions that you must acquit if you do not find every element beyond a reasonable doubt, meaning you must acquit if you cannot find that this was for the purpose of sexual arousal or gratification. That was repeated throughout the jury instructions and the arguments of both prosecution and defense. So even if they had posed I think this would be a more difficult case if they posed a question about beyond a reasonable doubt. The question that they posed was relative to dates and times. So the jury instruction itself did not negate beyond a reasonable doubt. It would only be a violation of in re Winship if the reasonable doubt jury instruction itself was flawed. And in this case, it was not, which goes to why this is not a structural error, because we are not talking about the definition of what beyond a reasonable doubt is. Here we are talking about whether the jury instruction was error. And in this case, I cite that it was plain error because the defendant didn't object and acquiesced in the giving of the jury instruction. So under this standard of review, there had to be error. I don't believe there's error under People v. Beluya, where the court stated that if you track the language of sexual conduct in the definition, then that suffices. That was an issue on appeal in that case. So under Beluya, there was no error. If there is now error, then it wasn't clear or obvious to the parties because the existence of that case law, and also because the history of adding the element was to clarify the definition so that the jury understood what the definition of sexual contact was.
Yeah, but the definition, I mean, the element 5 that was added did not track the language of the statute in terms of sexual contact.
I believe that deleting, and I understand Your Honor's concern with that, but I don't believe that lay people see a difference between if or and, especially if the ambiguity.
I think it's may not necessarily be the wording, but the application. When you read, you know, all 5 elements and element 4, that the intentional touching, then the subsequent element 5, if it could be reasonably construed. And so if the proper language was given, then there was more clarification who had the burden. But if you use just the article the or the, that or the, it as what Justice Merriman, as I understand it, our concern is pointing out, that then could be read as a presumption that the following happens. The element 5 is the consequence. And that relieves the burden of the government from having to prove that beyond a reasonable doubt.
I understand that, I understand the question. I believe still that the jury did not interpret it that way. Because by acquitting him, they were saying, even if this is a presumption, let's say they did read it that way. Even if this was a presumption, I, as the trier of fact, I'm rejecting the presumption, and that's what they did. So this is different from people.
So what evidence do you have on the record that leads you to that understanding?
Simply because of what the actual acquittals were. So if you look at they returned a guilty verdict for touching her thigh when she was 10, touching her buttock when she was 12, touching her buttock when she was 13. They acquitted him of causing his primary genital area to touch her buttock when she was 7 and causing his hand to touch her buttock when she was 10. So the evidence, that makes sense because the evidence was they acquitted him of the act when she was sitting on his lap. So they rejected, even if they were reading a presumption into this, that's the jury saying, even if that was the presumption, we weren't required to accept that, and we did not, because having someone on your lap can be innocent. So that's the evidence. It's by their verdict what they are, because we know about the conduct because the actual body parts were a part of each count of the indictment. So that's the evidence that goes to that. Now, so again, there was nobody made the argument that the people were relieved somehow of the burden. The burden beyond a reasonable doubt was repeated many times. And even in the absence of the alternate inference language, which I do believe that issue is precluded in and of itself under the invited error doctrine, because the defendant had a basis for doing so, requesting the removal of the instruction, which is akin to the defendant intentionally relinquishing a known right, which would be waived and not simply forfeited on appeal. Now, as far as the standard of review, so back to the plain error standard review, even if there was error because of the deletion of the word if, it did not affect his substantial rights because, again, by the evidence in the record of what their verdict was, we can see that they weighed the evidence in Mr. Denamarquez's favor for 2 of the counts for him. So under plain error standard review, the defendant's convictions should still be affirmed. I did pose whether it is harmless error standard review because the other jurisdictions that have reviewed this issue reviewed under a harmless error standard review, and those jurisdictions still upheld convictions, even review under harmless error. When those jurisdictions said, yes, we think it's error for the instruction not to be, and the defendant had to accomplish the conduct for the purpose of sexual arousal or
But
gratification.
in those jurisdictions, did defense counsel object to the jury instruction?
In those jurisdictions, that I believe the defense counsel did not object to the jury instructions as well. I was trying to ferret that out, but that's what my memory is. But so even those jurisdictions.
But that's not the law in our jurisdiction. If you don't object, it's plain error.
Correct.
Yeah.
Correct. So I do believe that it is plain error, and it doesn't arise to structural error again, because we're not dealing with the definition of beyond a reasonable doubt, which is what Henry Winship was about. We are dealing with what the jury believed as to who had what burden. And I do believe, to answer Your Honor's earlier question about does the defense counsel's consent to the alternate inference instruction, whether that is related to this in any way. And I believe that shows that the error was not clear or obvious under plain error. If we had a diligent trial defense counsel saying, this other jury instruction is lowering the burden of proof. The alternate inference is lowering the burden of proof. But he did not think the same thing of the element 5, lowering the burden of proof. So that is, I believe, shows that this was not clear or obvious under
I
the law.
think it's a little different, at least in my mind. It didn't, element 5 didn't lower the burden of proof, it removed the burden of proof, is the argument. That there is this implication that there's a presumption of sexual arousal or gratification as a result of the intentional touching. I think that's a little different. That just removes the burden of proof on the part of the government. It didn't lower it.
Understood. However, I think that this would be a stronger argument for Mr. Denamarquez if we had a conviction on all the counts, because then there would be, can be argued that there was some sort of confusion about the permissive, the presumption. If the jurors did indeed think of it as a presumption.
Then
Uh,
aren't we speculating what the jury thought?
I'm sorry.
Then aren't we speculating what the jury thought?
Yes, but at this point on this level, we're always speculating, just because we don't have a record of, we have a record of the questions they pose, but we don't have a record of what is going on through their mind. When we're considering these issues. However, when you look at, like, let's say we look at the prosecutor's closing argument, even though it's not evidence, the prosecutor never said, this is automatically construed for sexual purpose or gratification. Putting somebody on your lap is automatically construed as that. He didn't say touching someone's butt is automatically construed. In fact, the prosecutor laid out how the definition, like how we know that this is sexual for the purpose of sexual arousal or gratification. He laid that out repeatedly. And although Mr. Perez's argument is that there was proof in this case that the touchings were accidental, the victim's older sister actually told the jury that he had also touched her in a similar manner. Touched her buttocks in a similar manner. And both the sister and the brother both indicated that they actually had witnessed Mr. Denamarquez touching the victim in this manner. And so it wasn't a matter of, in this case, whether there was a touching, because there were 2 eyewitnesses that there were touchings, at least for 2 of the 5 events. From what I recall, the issue in this case was not that there was a touching, but whether it was accidental. And I believe that was even conceded in part of the defense argument is, hey, yeah, he might have put her on his lap, but people do that, if you're a male relative, you do that, that can be playful. And so in this case, while, yes, at this juncture, all we can do is speculate, but there's testimony in the record and arguments made in the record where we can come to the conclusion that the actual contact itself is not disputed. It's that the jury was charged with discerning what is unlawful contact and what is lawful contact. And my last point is that if you put the word if in there, because that is the questions posed by the judges, even if you put the word if by there, I don't think it would have affected the outcome. And that is part of the standard review, what this court would look to. It wouldn't have affected the outcome because they specifically said some of the contact was playful and unlawful. And so that's why I do not believe that this should be reversed and remanded to change the word if, or to add back the word if.
Here the argument of defense counsel is that the exclusion of the alternate inference instruction suggested a lower degree of doubt than the reasonable doubt standard. But there are courts that have actually found that the inclusion of the instruction suggests a lower standard of proof, and you assert that the government asks for this instruction, generally asks for this instruction, but it seems like a number of circuits have determined that if you do include that instruction, it could mislead the jury into thinking that the government's burden is actually lower than the reasonable doubt standard.
So I believe there is a split. So some jurisdictions say that it accurately reflects the law, so it's okay to include the jury instruction. And the other jurisdictions say that it lowers the standard of proof to preponderance of the evidence. So in this case, anytime a defense counsel is going to say that we are lowering the standard of proof, we would agree to the removal of it if that's in fact what they thought. And in this particular case, the defense counsel didn't just say, I want the removal. He specifically said, this alternate inference instruction is going to hurt my client. That was what specifically he stated. And so that's why I do not believe that that is reviewable on appeal, because that is evidence of intentionally relinquishing a known right to have that jury instruction given. If there are no other questions,
All right, we have no further questions.
thank you.
Mr. Parrish, you have 5 minutes remaining.
I have nothing to add, Your Honor, unless the court has questions.
Any questions?
I would like to ask you to comment on the jury question that came in. Do you think that adds any light to this analysis or discussion?
What I recall, the jury instruction pertained to time periods.
The question had to do, how do you assign incidents to the various charges for time periods?
Right. So, first I would agree with the court's earlier comment that we can't read too much into what the jury did because it is speculation. And also, Justice Carbolito's comment about, what evidence on the record supports the people's position. Insofar as there were difficulties of proof regarding timeframes,
Mr. Parrish, could you just lift the mic, please? Thank you.
regarding dates, birth dates, and incidents. It goes again to inference. Could the jury have inferred that the testimony given pertained to the people's theory as to date? Could they have inferred that it was, and could they have equally or reasonably or more reasonably inferred that it wasn't? If I'm understanding the court's invitation for me to comment correctly, that would be an example of the problem with the instructions as given. Because if the jury could have inferred, yeah, maybe it happened during this time frame and maybe it didn't, but we can't consider that maybe it didn't, because even though that's a reasonable inference, we can't consider that. In that regard, it's an example of the problem with the instructions.
I think the question more is that in terms of the jury note that was sent to the judge and asking, how do you align the various actions with the charges and the various counts, is how does that confusion relate, in my mind, to the reasonable doubt instruction? How is there any tie-in? Because here the argument is that your argument is that element 5, created a presumption of that the intentional touching was for the purpose of sexual arousal or gratification, instead of that the government had to prove this beyond a reasonable doubt, element 5. So how does that jury note relate to the reasonable doubt shortcoming, if any?
Insofar as they didn't specifically ask about reasonable doubt, but
Yeah.
instead focused their question on like a different issue. I think this would call for me to speculate, but maybe one reason is because the jury was clear in its mind that if we can reasonably construe sexual arousal or gratification, even though we can also reasonably, if we can reasonably construe that, then we must convict. Maybe that was clear in their mind. I don't know, but maybe they knew that even if there was another reasonable inference, they would not be permitted to adopt it. And maybe that's why that was the focus of the question. But I would just add that the issue, I did consider raising sufficiency of the evidence regarding aligning timeframes alleged to the evidence presented. I did consider raising that as an issue, but declined to do it because of the standards. As it applies to the issue that we've raised in this appeal, I think it's noteworthy that there were issues regarding aligning those dates to the proof. It's noteworthy because the jury, I think the jury was deprived of considering that maybe it didn't happen. They were prohibited from reasonably construing that it didn't happen within those timeframes. I think that's how I would answer that.
So I have two questions I want to ask. On instruction 7A to 7E, is it your position that if you deleted that last element, then the instruction would be sufficient and would be correct? Element 5?
I think, no, I think I think the fact that it was made an element causes a problem under Winship, because Winship requires people to prove beyond a reasonable doubt every element. But the fact, if it had been removed from an element, it's still an element. It's still an element because what is sexual contact? Sexual contact is defined.
So how would you suggest that if you would write the instruction in a constitutional manner, as you assert, what would that instruction look like?
The people must prove beyond a reasonable doubt that the defendant's contacts were for the purpose of sexual arousal or gratification. Not that it's possible. They must prove it.
But that's not the law. I mean, that
And we rejected that in Morales. They don't have to prove that it's for the purpose of sexual gratification. It's that they have to prove that it can reasonably be construed for sexual gratification. I mean, that's our holding in Morales. That's not what the statute requires. You don't have to prove the actual sexual arousal or gratification.
Wouldn't just 6E be sufficient? I mean, take element 5 away and rest on 4 elements plus the other jury instructions. We always say you read the instructions as a whole, and 6E would fill the gap as what you're trying to do in reference to substituting element 5.
Right. We remove the definition of sexual contact from the elements.
No, it's still an element, sexual contact. You still have to prove sexual contact, but sexual contact has within its definition that the touching can reasonably be construed for the purpose of sexual gratification.
Right, but the four elements would have been.
I agree.
Without that definition.
Without because
Right.
sexual contact has that definition.
Right. So it would be those 4 elements, and then I don't remember what 6E was.
6E is the definition of sexual
Sexual
contact.
And the question was, if the court had left it as the 4 elements and then the definition, would that have been okay? I still think we have the problem of unreasonably construed, because you deprive the jury of construing otherwise.
But 6E fills that gap. The definition of sexual contact.
Right, but the problem that we're arguing is that it defines it as if the contact can reasonably be construed as for sexual arousal or
That's what
gratification.
the statute says, and in Morales, we held that they don't have to actually prove that it's for the purpose. They have to prove that it can be construed for sexual gratification. Because it's a difficult burden to actually prove that it's for the purpose of sexual arousal or gratification.
I would respectfully disagree. For example, you're on a subway, you see somebody on a subway, a man standing next to a woman, his body's against hers. You don't know them. Can you reasonably?
Well, that can reasonably be considered, and that's what the jury's role is. I mean, you're standing next to someone and your elbows are touching. I don't think any reasonable person would construe that as being for the purpose of sexual arousal or gratification.
I guess it depends on the circumstances and the evidence presented, but I see the potential for a directed conviction.
Well, let's say that, I mean, I don't know that we have a clear understanding of what would have been an acceptable instruction for you, but let's say we had an acceptable instruction under 7A and E, and it was one that was not problematic. Is the alternate inference instruction standing alone a cognizable claim for error? So if 7A to 7E was not an issue, would you still argue that including the alternate inference instruction or excluding it in this case, because that was what you argued for, was to exclude it, would that be a problem?
It would be, and
Why?
recognizing trial counsel's reason for doing it, trying to protect the reasonable doubt standard. Because you have the instruction is given where and reasonably construed.
No, but we're saying everything is fine as far as that instruction is concerned. You're satisfied, there's no issue, you got the instruction you wanted, you think it's constitutionally sufficient. So now you have this other alternate inference instruction. If hypothetically, that is, then asked to be excluded.
Meaning we have a different instruction than when it was given in the trial, or meaning I leave that issue alone.
Yeah, it's not an issue in
Okay.
this case.
So, yes, because the jury is deprived of exercising its discretion to infer that while it could reasonably be construed as for sexual arousal or gratification, it's deprived from reasonably construing that it was not. And if it was equally reasonable, then the jury would have been mandated to adopt innocence versus.
So you think it's not at all dependent on the other instruction, that standing alone, it also has its own problems?
Yes,
Okay.
But Mr. Paris, aren't there other instructions that say the defendant's presumed innocent?
there are, yes.
And that's not, in my opinion, one.
No, because you have this language, which I'm leaving alone, which says can reasonably construed as sexual arousal and gratification. You don't have the other language, which says if it can be, but it can also be reasonably construed as something else. You don't have that instruction anymore, or you must adopt innocence.
All right, thank you both, counsel, for your arguments. The court will take the matter under advisement. We will issue a written opinion and